Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
This season, Instacart has your back to school. As in, they've got your back to school lunch favorites, like snack packs and fresh fruit. And they've got your back to school supplies, like backpacks, binders, and pencils. And they've got your back when your kid casually tells you they have a huge school project due tomorrow. Let's face it, we were all that kid. So first call your parents to say I'm sorry, and then download the Instacart app to get delivery in as fast as 30 minutes all school year long. Get a $0 delivery fee for your first 3 orders while supplies last. Minimum $10 per order. Additional terms apply.
Across America, BP supports more than 300,000 jobs to keep our energy flowing. Jobs like expanding our biodiesel capacity in Washington state and reducing operational emissions in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
Content warning, this episode includes discussion of the murder of children. So another day, another bunch of filings in the Delphi case. By the Delphi case, of course, I mean the case of Richard M. Allen, who is charged with the murders of Abigail Williams and Liberty German. So there were some interesting filings in the case today, including Judge Gull has made a decision on one motion, and then the defense has filed another motion.
And a memorandum to match it.
So we're going to discuss all of that today and see if we can figure out what it might mean.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is The Delphi Murders, a motion to disqualify and a motion to dismiss. Okay, so as Kevin said, we have 3 new filings in the Delphi case today. First, why don't we talk about Judge Frances Gull's decision around the defendant's verified motion to disqualify. And that what that essentially is the defense saying the judge should recuse herself.
Yes. Their argument is that Judge Gull has a bias against them. And in support of that, they basically point to the fact that she tried to remove them from the case. She has indicated she finds them to have been negligent. She's called their strategy into question. She's accused them of lying in court motions, in court filings. So the implication from all of that, they say, is we're not confident we can get a fair trial from this judge. And that is perhaps an understandable position and concern for them to have.
So now we have the judge ruling on that, and maybe not to anybody's surprise, she ruled against that. She's not going to take up their motion to disqualify. And what she said specifically is she did take it under advisement. She did consider the pleadings, but she's denying it without a hearing. And also cites something specifically as her own reasoning behind not taking it up.
She said the United Supreme Court unanimously denied their previous request to have her removed.
On January 18th, 2024.
Feels perhaps a bit disingenuous because some of the arguments that the defense has raised in their most recent motion to have her disqualified were not considered by the Indiana Supreme Court. For instance, they pointed out that when the attorneys who Judge Gull had selected to take on the defense were in charge of the case, she indicated that if they wanted a hearing on the Franks motion, she would grant that. When Rozzi and Baldwin came back on, she indicated pretty quickly that they would not get a hearing. So there was new things added to the argument to have her disqualified that the Indiana Supreme Court did not consider.
Do we imagine that Rozzi and Baldwin can appeal this decision to bring it to a higher court at this point?
I would assume that ultimately, if the trial happens and does not go their way, this would be something that would come up on appeal. I would imagine that if Judge Gull stays on this case and conducts the trial, every single decision she makes is going to be closely scrutinized for the possibility of bias.
Okay,
so
yeah.
what do you make of that?
Well, I mean, that's how I see it. One thing that a lot of people who we talk to behind the scenes who have nothing to do with this case but have legal careers and kind of understand how things work, they always said, well, they can't both stay on. You know,
by both you mean the defense attorneys and Judge Gull?
Yes. So because of this, because it's the trust has broken down so much, the relationship has broken down so much, so it just there's a real sense of concern, I think, in this case that this is going to be rendered a practice trial because there's going to be a successful appeal based on the judge being biased. At this point, that's not necessarily Kevin and I even saying bias or no bias. We're just saying that the appearance can be, by a reasonable person, argued.
If we're not in Judge Gull's heart, we don't know what in her heart of heart she believes about all of this. None of us are except for Judge Gull. All we can do is try to figure out how this might look to reasonable people. And reasonable people can see her regularly denying hearings, can see her questioning their strategy, trying to remove them from the case, calling them negligence, suggesting they're not qualified to give Richard Allen the defense he deserves. You can look at all those things and say, maybe she has it in for these attorneys. And if a reasonable person could come to that conclusion about this particular judge, then this judge is not the person who should be overseeing this case.
And it's not about...
And that's not a slam against her.
No, it's not actually. It's just a matter of where we are and being realistic about it. And it's actually, you can say that, well, I'm a reasonable person and I think they're just behaving in a way that is prompting her actions, and that's fine. It's just more of, could a reasonable person who's not some conspiracy theorist come to a different view? And our opinion is certainly possibly at this point, I think we'll have a better sense going forward. One thing that's, you would want to see if perhaps things were going to work out going forward is the judge, at the very least, giving the defense a chance, having hearings when they ask for them, putting everything on the record. That would combat some of the concern. It wouldn't really fix it, frankly, but it would certainly be better than not granting any defense hearings as a rule going forward.
So my question, one thing I'm wondering is, it seems apparent that it would be difficult, if not impossible, for Judge Gull to oversee a trial with these two defense attorneys. So I wonder, is she intending to keep them on? Is she intending to try to remove them in a different way?
And that's where a real question lingers for me, too, because I think some of the behavior could make more sense if there is a very clear path to, in her mind, to removing them in the proper way, and that won't be challenged successfully. Because then you're saying, well, she's going to stay on, right the ship by removing them and bringing on new defense attorneys. But to me, it's not clear that she can even do that. And I think a lot will depend on the opinions in the Supreme Court hearing, because if they're saying, listen, this leak was really bad, but it's, contempt of court is fine, but you can't remove them. They have to stay on. Then I don't see that. There's no recourse there for. If they're saying, okay, you want to remove them? Here's how. Then obviously it's different. But it's not clear to me that, the argument that Mark Lehman made during those oral arguments was like, you can't remove them for something like this. You can remove them for like a conflict of interest, but not for gross negligence.
And when we talk about the possibility of her doing things that could create the perception of bias, this is a much less substantive issue. But one thing that comes to mind is she scheduled, without consulting with them, a hearing on February 12th. And they filed a motion saying we need more time. And also, as a matter of fact, Attorney Rozzi is going to be out of state on that date on personal business that's been previously planned. Let's schedule it for a different date. And that's the sort of thing that you would expect a judge to pretty routinely grant without much fuss or muss. And she's not granted that continuance as we speak. Maybe by the time this episode is out, she will have granted that. Maybe she'll grant it tomorrow. But I'm not sure why she's waited so long to respond to that. Because that's not something she needs to spend a lot of time analyzing records and going through files and interviews to come to that conclusion.
I agree. Also, I don't see what the reason is to not continue that.
Because again, that could be problematic if she insists upon a hearing on the 12th to address the alleged contemptuous behavior by the defense attorneys, and they previously indicated we won't be ready to have a proper defense by then. How valid is that hearing going to be?
As I've said, the legal process is not people jumping out behind corners yelling surprise, and trying to ambush each other. Typically things get continued because you want everybody to be ready.
And
that doesn't mean you have to be sympathetic with the defense team. You can certainly say, I think the leak was their fault and they should be punished via contempt. You can say that, but the process should still work the same no matter what you think about the outcome.
And you can say, well, maybe if a particular party in a particular case is filing lots of motions
to continue, yeah.
If they're doing it just to delay, if they're doing it in bad faith. Just speaking as an outsider, it seemed that the reasons the attorney cited for that continuance seem to be valid.
Well said. And it just kind of speaks to this uneasiness because you have two groups, the judge and the defense team within this case, who they're, it feels like it's like a standoff still, even though everyone's back on. And I sort of question the Indiana Supreme Court's decision there. Not that they, ruling for the judge or against against one side or the other. That's one thing. I think everyone was prepared to accept that, but they've essentially created a situation where you have this like kind of ongoing war. And one thing that Chief Justice Loretta Rush kept saying was like, I want to get this case back on track. And if the case is on track to an automatic appeal, I don't really see how that's really back on track. But I don't know. Maybe their opinions will give more light. I'm certainly not trying to question the decision of the highest court in our state. It just seems like the outcome of this is something that like is very academic, but perhaps not super practical.
Getting the smile and confidence you've been dreaming about, all from the comfort of your home, isn't a total mystery with Byte clear aligners. Just don't be surprised if all your friends start asking, what's your secret? Begin by ordering your at-home impression kit today for only $14.95. Byte clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces, plus they offer flexible financing, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
What makes a life a good one? Is it the adventure you have? Or the friends you find along the way? Maybe it's pursuing your passion while striving to protect, defend, and save what you believe in every single day. So what makes a life a good one? In the Coast Guard, we think it's all of the above and more. But you'll have to find out for yourself. Visit gocoastguard.com to learn more.
With that said, why don't you tell us what the defense filed today?
Well, they filed a motion to dismiss for destroying exculpatory evidence, as well as a adjacent memorandum of law in support of the dismissal. So those were the filings from the defense team today, and they go into claims about destroyed exculpatory evidence. Before we get started, what is exculpatory evidence?
So exculpatory evidence is, in this case, it would be evidence that would tend to show that Richard Allen was not guilty of these crimes. This could be, hypothetically, this isn't what it's about. It could be evidence that at the time of the crimes, Richard Allen was in San Francisco, halfway across the country.
Or like, yeah.
He couldn't have committed these crimes.
Right.
Or it could be some evidence that another person definitely committed the crime. That would be exculpatory towards Richard Allen, because if someone else committed the crime by themselves, Richard Allen wouldn't have committed it. So the state, when they have exculpatory evidence of a defendant, they are obligated to turn it over to the defense team, in order to make the process as fair as possible. Okay.
So exculpatory evidence, very important to a case. And what the defense is saying here is that some of it was destroyed. So based on that, the whole case should be dismissed. So the charge is dropped.
Yes.
Against Richard Allen, and that's it. So definitely a serious motion.
What was some of the evidence that they said was destroyed?
Well, what they're citing specifically is, of course, the defense's theory centers around a Odinist cult, which they say that two men, Brad Holder and Patrick Westfall, allegedly belonged to. Now, Brad Holder, we know from the Franks memorandum, had an alibi for the time of the murders. He was at the gym, seemingly, but also, but they think it was like a kind of a wide sprawling thing with, multiple people involved. So he's at the center of that because they say that Abby was dating his son. So Brad Holder and that group did come up early on as people, I think, in the orbit of the girls did. And he was interviewed on February 17th, 2017, 3 days after the discovery of the bodies, by, I believe, FBI agents. And that was taped. And what the defense is saying is that was taped over then. Like that recording was lost.
And so let's be clear. It is obvious that if I'm not going to make any statements here about whether or not I think Mr. Holder or his associates are responsible for this crime. But if you have someone who is a suspect in a crime and they're giving a statement to authorities within days of that crime, that's obviously a very crucial piece of evidence and information, because you can analyze what exactly are they saying in the aftermath of this incident. How are they saying it? What's their tone? What's their manner? Do they seem calm? Are they shifting around? So this footage of an interview with someone who the defense considers a suspect in the case is obviously very, very important. And it's obvious that it should not have been taped over.
It seems very sloppy, at the least.
And Brad Holder's son had a personal connection with one of the victims.
Yeah, so that's kind of the crux of what they're saying here. And what they're arguing seems to be that it's exculpatory because it's so close to the murders that if we had this, then we could compare his statements to later statements and see if maybe some things don't match up. And he's so important to our case. They're putting so many eggs in the Brad Holder, Patrick Westphal basket. The fact that we don't have this harms Richard Allen's case, harms his rights, therefore.
And they're asking for a hearing.
And they're asking for the case to be thrown out, but before you get to that, you have to have a hearing and present what your side is, and then have the state rebut it. So that would be the first step in that process.
So obviously this is a way that they made some similar allegations to this in the Franks memorandum, and there was no hearing granted in that. So now they're trying to get some of these same issues adjudicated.
So it's a relitigation of some of the Franks issues, but with a specific twist around exculpatory evidence, which of course is very important in a criminal case.
Very, very important. So I'll give you my quick take on this. I don't know. We can't know at this point because we don't have the information. Was this interview deliberately taped over? Was it an accident? What's going on here? I really think it's crucial to have a hearing to get all the parties involved on the record, offering sworn testimony, hash out what happened, and then try to figure out what to do next.
Say, people, we don't have enough information. You know that's not going to stop people from weighing in, though.
Yes.
I think that, to me, there's been so much from the defense that seems really exciting, and then you look closer, and it's, you can kind of scratch the gilded surface off with the Franks memorandum I'm thinking about, and this emergency safekeeping order. And so that's I'm weighing that on one side of my mind. On the other side, I'm thinking exculpatory evidence. This is very important, and Allen should have the opportunity to a robust defense, and if that means centering upon Brad Holder and key statements from him have been lost, then that's pretty serious. And so I would think that there should be a hearing as well, because I also think that, frankly, from the public's perspective, having a hearing where prosecutor Nick McClelland can go back and respond to some of this, that tends to be a good thing, because then there's both sides out there. Both sides are able to state their piece and then move on. So that's kind of where I am.
I would think that if Judge Gull chose to deny this without a hearing, it would certainly have the appearance and perhaps the reality of bias. I think it is very important to get to the truth of these matters. Was the interview and this other material, was it purposely destroyed? Was it an accident? Do we still have records of the interview that will be sufficient?
We have records of the interview. They noted that the reason they found out about this is because there's a report of the interview. What they're arguing is that a written report does not have every statement verbatim. It has the crux of the statements, but it does not have the verbatim statements, so that, you know, maybe he said something offhanded that has new relevance later, and that's lost. So I think that's so what they have a facsimile, but they don't have the real thing, and they're arguing that is problematic.
So I say have the hearing, hash it all out, get it all on the record, and then if Judge Gull chooses not to grant the motion to dismiss, at the very least, the defense has had the opportunity to publicly air everything they have.
And there's a record.
And there's a record so that other courts in the future could look at it.
And see why Judge Gull made the decision that she did. And see all the arguments. Yeah, I think in this case going forward, I'd love to see more of a record, not less. And I'd love to see hearings, and doesn't mean anybody, you know, certainly it's not, Judge Gull to me ruling against them at times is not biased. Like people are always going to get ruled against. It's more of like if you have a situation where a judge does not even hearing one side out, that becomes a problem on appeal.
At some point, something becomes a pattern, and maybe we reach that point sooner if the judge has publicly said that she finds the attorneys to be grossly negligent. And obviously, a judge is not obligated to hold a hearing every time attorneys ask for one.
No.
A judge can feel, oh, this is just a waste of time. If I went to you, Anya, and said, Anya, you're the judge of this house.
Yes.
And I really feel that we should quit the podcast and move to China, and I'd like to have a formal hearing where I present my arguments to that effect, you would say, Kevin, that is never, ever going to happen. It would be a waste of my time to hold such a hearing.
And then
hearing.
I would hit my gavel really hard.
But if it's a situation where if you don't grant me a hearing, I'm going to somehow appeal it to your parents.
What?
Or, go up higher. At some point, you need to create a record. You need to have the hearings.
My dad listens to this show, so I bet he's going to be very happy that you think he's the higher court here.
Yes.
Yeah, that is it. It's not. I think people kind of tend to like to see things in black and white. To me, this situation with the judge and the defense, speaking in a macro sense, not necessarily just about this possible hearing, is sort of like I love my little pebbles, right? My little pebble analogy with Richard Allen, there being pebbles that stack up against him, and maybe the defense can remove some, and that's good for him. Maybe the prosecution can put some more on, and that's bad for him. To me, this kind of ongoing Cold War, or what appears to be a Cold War between the judge and the defense, it's like each little thing that happens is almost like a pebble stacking up, and if enough stack up, then I think there's just basically a very higher, much higher chance of a very successful appeal. And you can argue that at this point there already is one, just because they're all back on. Like, that's the baseline. And to me, if the baseline is already so high in favor of having this first trial be totally meaningless, then things should be proceeding with a lot of caution around that. So, because it's already, the weights are already stacking up, and I don't know, it concerns me.
I've alluded to this. I'm not making any statements if Judge Gull has done things right or wrong.
No.
I don't know what's in her heart, but I've alluded to this, that if a judge has said on the record that certain attorneys and the way they've handled this case, they're grossly negligent, they're not doing a good job handling this case, and this judge has said this on the record, it is difficult for me to understand how that judge can preside over a trial without there being an appearance of bias.
Yeah, I have concerns. I have similar concerns. It's not about saying defense are right, judge is wrong, defense are right. It's more of what is the best thing for the integrity of this case? I think that's where we tend to be most interested. What is a good path forward for the case so that Richard Allen's rights are protected and so that Abby and Libby's families don't have to necessarily go through this many, many times again because it just keeps getting appealed successfully. It's going to be appeals no matter what, but are they very powerful appeals that will likely be successful? That's the question. Because when you have that, then something went very wrong.
Do you feel it's possible for a judge to appear unbiased after she's made the sort of statements that Judge Gull has made about Rozzi and Baldwin?
Well, I think that's a hurdle to clear, but I tend to think that it's always good to start over, right? And kind of go forward. And I think things that would, if she can make an argument at the end of the day of, yes, I did think they were grossly negligent. And I handled it in the way I thought right. But after the Supreme Court said they have to come back on, to me, that was like a blank slate and let's move forward and figure it out. And look, I granted these hearings. I heard them out. Maybe I ruled in their favor a few times because I thought these arguments were reasonable. I think if you can point to that, you have an easier time than if you can point to, I routinely denied every hearing they asked for, regardless of the circumstances, and never consulted them on timing. I think, you could still make arguments on both, but I think you'd have an easier time with one than the other.
I just hope there is a hearing on this. My instinct is that the case would not be dismissed. These bits of exculpatory evidence don't seem to directly implicate the truth or falsity of the case against Richard Allen. They don't seem to touch upon his confessions, his admitting to being at the scene, or the bullet, or things of that nature. That doesn't mean it's not serious.
It is serious, but I tend to agree with you. And I tend to also just question. So Brad Holder had an alibi for that day. And I guess I would love to know what the explanation is around that. They alluded to some accomplice running off to the gym with his gym card at the time. I don't know. I would love to hear more about how do you vault around that?
Well, I guess to play devil's advocate, you could suggest someone else used his gym card to create the false impression he was there at the gym instead of being at the crime scene. You could also argue that maybe he wasn't at the crime scene, but he was still responsible and directing what happened at the crime scene. But again, I'm not making any statements on his guilt or innocence. I'm just suggesting possible avenues and arguments.
I'm just admitting that I have a lot of trouble with that. Yeah. I think I would like that theory a lot more if there was more of a sense that some of these people were definitely there and tied there by phone evidence, by people citing a group of white males hanging around in the woods that day, because we know there were plenty of other people on the trails. Something putting them there. That would be, to me, elevate it a lot. And again, the focus on Holder always brings me back to like, okay, but so this had to be this had to be such a wide-ranging conspiracy that he went in there knowing that he was going to do crimes to the extent that he sent around some lackey to go to the gym for him.
Right.
That's a lot of planning. Also, a lot of opportunities for things to go very wrong.
Now, of course, we have, in this discussion, we've primarily been focusing on the allegations about an interview with Mr. Holder being destroyed, but also in the short window of time where the information on this recorder was taped over, there was also an interview conducted with Patrick Westphal, which has been lost. Remind us who Patrick Westphal is.
Patrick Westphal is the person that the defense alleges was in a quote-unquote Odinist cult with Brad Holder, speaking with people who are involved in heathenry, which of course is an inclusive group that worships Norse Germanic gods, they indicate to us that they see more these guys as possibly a satru, meaning that that's folkish, certainly has racist overtones, but does not have necessarily the violent connotations of Odinism. So just to be clear, like when they are saying Odinist, they're using that as a catch-all term, not specifically referring to the white supremacist prison gang, seemingly. So Westfall is allegedly buddy-buddy with Holder, and they're part of the same religious group, and the defense argues that he's one of the people who was involved in the murders.
And so interviews with him were erased, as well as interviews with Mr. Holder. Another interesting thing is, a minute ago you were just saying, I really wish we had phone data and we knew where these men were at the time of the murders. And in the motion, the defense points out that they have been given a search warrant that was prepared to be given to AT&T to get phone data on the phones of Holder and Westfall. And it indicates in that search warrant that the murders had potential religious significance. And apparently those warrants were never served.
I'm assuming that warrant came from Todd Click, Kevin Murphy, Greg Ferenczi, the investigators who were predominantly on that.
We don't know.
Well,
all we know is this warrant was prepared and never served. And the warrant, at the very least, supports the idea that these men were being investigated seriously for possible involvement in the crime.
I'd be curious about why it was never served. Was it a situation that it was too weak, it didn't get to probable cause? Were other angles taking more importance at that time? I'd be very curious.
Those are good questions. It's possible, yeah, there wasn't probable cause. I think the defense would say, gosh, it's interesting this isn't served, and at the same time, interviews with these guys are getting erased. Maybe a cover-up. And so, again, this is one of the reasons why a hearing would be absolutely crucial.
Well, let me just also note, though, I think it's important because my understanding, when I mentioned the phone evidence, my understanding is that the location of different, or the approximate location of different phones in the area that day were collected and then used to like indicate who's there and who's not there. So if my phone, like they could see my phone number appearing there and then they look it up and okay, Anya Kane was on the trail that day, right?
Right.
So when I say phone evidence, I mean more of that as opposed to what was in their specific phones. That to me, were there unidentified phones that could be tied to some of the people that the defense has mentioned? Was Richard Allen's phone there that day, for that matter? In his story, he indicated that he was looking at his phone. So that could either confirm his location or kind of raise questions about why he said he had his phone when he didn't. So to me, that's, just to clarify, that's what I mean when I talk about phone evidence.
Understood.
It's a way of locating people there. And frankly, if you have like a cluster of a bunch of phones that are not, that are burner phones and that are hanging around and never identified, then that gives some credence to the possible defense theory.
The defense also would argue that their motion even extends beyond that there's other exculpatory evidence out there that they claim was at least attempted to be concealed from them, including the identity of the Purdue professor, Jeffrey Turco, and things such as the letter that Todd Click wrote indicating that his belief was that Richard Allen was not involved. So again, these are very serious charges. Was the state really trying to conceal things? Was it communication errors? Was it just innocent errors? These are reasons why we should have a hearing. Whether you think the defense has a history perhaps of exaggerating, or so maybe that's not true, or maybe the prosecution really is doing all of these shady things and trying to cook up a case against an innocent man. We need to get people sworn. We need to get them under oath, and we need to get to the truth of these very serious allegations. So I would hope that Judge Gull would grant this hearing. So with that, we'll obviously keep an eye on this, and thank you so much for listening.
Thanks for listening, everybody.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.